Honored guest speaker, Acting Justice of the Constitutional Court and Nelson Mandela University Chairperson of Council, Justice Nambitha Dambuza. Vice Chancellor, Prof. Sibongile Mutwa. Deputy Vice Chancellor, Teaching and Learning, Dr. Mxenge. Mxenge family members, Ms. Lulama Mxenge, Ms. Nonkululeko Mxenge, and Mr. Bontle Ndlovu, who is also a Mandela University student. The JP of the Eastern Cape Division and other members of the judiciary in attendance. Representatives of the different law societies, the Bar, Sidebar, and the Department of Justice and Constitutional Development, and the Department of Higher Education and Training. Members of the university management, council members, DVCs present, staff and students, in particular, staff and students of the Faculty of Law, the executive deans, deputy deans, and senior directors, honored guests, family, and friends, all protocol observed. Before I welcome you and commence the official program for this evening's lecture, let's all take a moment and familiarize ourselves with the emergency health and safety protocols for this venue. Nelson Mandela University welcomes you to this gathering and takes your safety very seriously. In line with our university values and ethos, we wish to share the following safety protocols to be adhered to. We all know that accidents and emergencies do occur sometimes. We need to be prepared for the possibility. To do so, please familiarize yourself with the emergency exit points. In case of an emergency, an alarm will sound, but remain calm, as this might be loud. Look for the green running man sign above entrances or exits in the venue. Calmly walk to the emergency exit points. Please help those who need assistance. If there is an elevator on the floor, do not use it. Find the exit stairwell. Proceed to the assembly point outside. Inform your superior of any missing persons. Follow instructions given by the emergency controller. Do not leave the assembly point until the all clear has been issued. Nelson Mandela University thanks you for your understanding and compliance with the emergency health and safety protocols. Siyabulela, thank you, danki. Ladies and gentlemen, honored dignitaries and esteemed guests, on behalf of the Executive Dean of the Faculty of Law, Dr. Lynn Biggs, it is my pleasure to welcome you to the prestigious Griffiths and Victoria Mxenge Memorial Lecture as part of the Institutional Public Lecture Series delivered tonight by Acting Justice of the Constitutional Court and Nelson Mandela Chairperson of Council, Justice Nambitha Dambuza. We are gathered here this evening to commemorate the lives and legacies of Griffiths and Victoria Mxenge, two extraordinary individuals who dedicated themselves to the pursuit of justice, transformation, and equality. My name is Phumelela Kwanini from the Faculty of Law, and I will be your host this evening. It is my honor to now welcome the Nelson Mandela University Choir, internationally recognized for its multicultural membership and diverse repertoire, who will be performing for us this evening, conducted by Mr. Robert Gilmer.
You can rest, my dear, the sun is here. The hills untie the bonnets, the bobolin's begun. Then I say to myself, this must have been the sun. You can rest, my dear, the sun is here. But how he says, I do not know. And what I saw just left me blind. Children climbing a purple star, laughing all the while. They reach the other side. A dawn
We are privileged to have with us this evening the Vice Chancellor of the University, Prof. Sibongile Mutwa, a visionary leader whose guidance and stewardship has helped to create an identity for Mandela University as a leading institution in service of society. I now invite the Vice Chancellor to share a few words with us.
Our program director, Phumelela Kwanini, thank you for hosting the program this evening. I would like to recognize our guest speaker for tonight, Acting Judge of the Constitutional Court and Nelson Mandela University Chairperson of Council, Justice Nambitha Dambuza, the representatives of the Mxenge family that are with us, as the program director has identified them. Thank you very much to be with us this evening and many, many years before today. I would like to greet the Eastern Cape Judge President, Judge Selby Mxenge, the members of the judiciary in attendance, representatives of different law societies, the bar, the sidebar, and the Department of Justice and Constitutional Development, and the Department of Higher Education and Training. I had to ask Justice Dambuza, what is the sidebar? Because every year, my colleagues in the law faculty have asked that I mention all these different levels. So now I know. Thank you very much, Lynn. I want to greet the members of our governing council, the Deputy Vice Chancellors. I've seen Deputy Vice Chancellor, Professor Andre Kiet, Deputy Vice Chancellor, Dr. Mxenge, Professor Azwindini Muronga, and Lutando Jack, the executive deans of our faculties, and all members of senior and top management. I would like to greet in particular our executive dean of the host faculty tonight, Dr. Lynn Biggs, the academics, students, and staff, honored guests, and those that have joined us online. We do have very strong support as the university of our citizens of our metro. I forgot to identify and talk about our university registrar sitting right in front here, Mr. Edgar Dikoke. I would like to recognize the members of government, the different spheres that are represented here, the members of this community at Nelson Mandela Bay, the community in whose name we stand. It is a pleasure and privilege to welcome you all to this, the 2025 Griffiths and Victoria Mxenge Institutional Public Lecture honoring the stalwarts, the late Mlungisi Griffiths Mxenge and Victoria Nonyamezelo Mxenge. Griffiths and Victoria Mxenge devoted their lives to the pursuit of justice, freedom, and equality. Their contributions underpin the values of our constitutional democracy. They highlight the key role of the legal profession and an independent judiciary have to play in safeguarding our hard-won human rights and freedoms. In 2006, Victoria and Griffiths Mxenge were posthumously awarded the National Order of Luthuli in silver for their contribution in the field of law and sacrifices made in the fight against apartheid oppression in South Africa. The citation recorded that, and I quote, they paid the supreme price for defending the rights of the oppressed South Africans to exist in conditions of freedom, justice, peace, and democracy. And it also noted that as husband and wife, they forfeited family life in pursuit of the broader family of humanity, united under non-racialism, non-sexism, and justice for all South Africans, and I close quotes. Nelson Mandela University hosted its very first Griffiths and Victoria Mxenge memorial lecture in 2009. This was done not only to celebrate their bravery, their gallantry, so to speak, and their contributions in the struggle for democracy, but also to commemorate their legacy that serves as a permanent reminder of the vital role of the rule of law as a pillar of a stable democratic society. In this way, we continue to strain forward towards ensuring substantive equality, including equal access to justice and the need to hold powerful public institutions to account, including our own, ensuring transparency and safeguarding against corruption and abuses of privileges, rights, and resources. All our Mxenge public lectures have been very special, but this 2025 one is extra special because the speaker is none other, as I've indicated, than our very own chairperson of our governing council, Justice Dambuza. We know and appreciate how busy you are, Judge Dambuza. I know because I report to Judge. Judge is very busy with her work commitments as a judge, and we would like to express our university's profound appreciation for you to agree to deliver this year's Mxenge lecture. We are also indeed exceedingly grateful and humbled that the judge is our chair of our governing council, and she has agreed to lend her exemplary stature as a watermark that binds the work of this university together. In 2017, our transition to Nelson Mandela University represented far more than a mere branding effort by us as the university. It was an opportunity for us to re-envision the role of public universities in South Africa and Africa continent as a whole, inspired by our desire to embody the values and ethos of our iconic namesake, Madiba. We recognized and committed our institution to a standpoint that will be transformative and responsive and in service of society and advancing social justice. Our institutional public lecture series is one of the ways we engage with our multiple communities on topical issues of our time. These lectures facilitate and widen our university's entry points in order to narrow and bridge the gap between what is called town and gown, so to speak. In identifying possible topics for this public lecture, commemorating the Mxenge, we reflect deeply on issues of public interest and contemporary relevance in our society that will advance and will be advanced by what the Mxenges stood for. More than 30 years into our hard-won democracy, with all the challenges we face as a country, I would like to argue that public lectures that honor the memory and sacrifice of people like the Mxenges have become more important and crucial, not less so. And discussion on topics like the one of tonight's lecture are a vitally important contribution to the renewal of South African society that we all seek, not only for ourselves, but for our children and our children's children. We only have to think of recent events in the news, such as the sentencing of Johan Marey and the continuing trial of his co-accused for the 1987 murder of Caiphas Nyoka, the reopening of inquests into the death of Chief Albert Luthuli and Griffiths Mxenge and Boy Manki, and the recent reopening of the inquest into the deaths of the Craddock 4, Matthew Koniwe, Sparrow Mkhonto, Fort Kalata, and Stelo Mhlauli, to realize that an institutional conversation such as this public lecture is important, a contribution for us as the university, but also for the intellectual community as a whole that we should make to South Africa. With the title Holding Out the long arm of the law, we cannot think of anyone more qualified and more appropriate to deliver the 2025 Griffiths and Victoria Mxenge Lecture than our own Chair of Council, the Justice Nambitha Dambuza. I thank you this evening. Thank you.
Thank you, Prof. Mutwa, for your inspirational words and for laying the foundation for our engagement and the lecture that will follow shortly. I now call upon Dr. Lynn Biggs, the Executive Dean of the Faculty of Law, to introduce our guest speaker for this evening.
Good afternoon, everyone, and thank you for being in attendance this afternoon. VC, Prof. Mutwa, DVC, Learning and Teaching, Dr. Mxenge, members of the Mxenge family, honored guests, staff, friends, and family, all protocol observed. It gives me great pleasure to introduce to you Justice Nambitha Dambuza, who will be delivering this evening's lecture. Justice Dambuza is a distinguished member of the South African judiciary, serving as a judge of the Supreme Court of Appeal, where she has presided for the past 10 years. Before that, she served for 11 years as a judge on the High Court in the Eastern Cape, making her one of the country's most experienced and respected jurists. During her judicial career, Justice Dambuza has also held appointments in the Competition Appeal Court and, as you've heard, the Constitutional Court, where she's currently serving as an acting judge, contributing to the development of South Africa's constitutional and commercial jurisprudence. She has not only served the bench, but has also been a committed leader in judicial reform, education, and governance. Justice Dambuza is the chairperson of the Rules Board for Courts of Law, which plays a key role in shaping the procedural frameworks of our justice system. She is also a visiting professor at Rhodes University Faculty of Law in Mxenge, and also, as we are so proud to say, our very own Chair of Council. Her influence extends beyond South Africa. She sits on the boards of Global Judicial Institute on the Environment and the Southern African Legal Information Institute, contributing to legal transparency and environmental justice globally. Locally, she gives back through her work as a trustee of the Heatherbank Farm School. Justice Dambuza has also previously served as a member of the Judicial Conduct Committee of the Judicial Services Commission, a council member of the South African Judicial Education Institute, SAJE, chairperson of the Walter Sisulu University Council, and chairperson of the African Judicial Education Network on Environmental Law. From her early days on the High Court bench to her current leadership roles in judicial reform and legal education, Justice Dambuza has remained a steadfast advocate for justice, transformation, and access to law. Her commitment reflects to the very spirit of Griffiths and Victoria Mxenge, whose memory we honor here tonight. Champions of truth, equality, and the rule of law. We're indeed privileged to learn from her tonight as she shares her insights and reflections. Ladies and gentlemen, please join me in welcoming Justice Dambuza to the stage. The floor is yours.
Thank you, Professor Biggs, for that beautiful introduction. I was wondering as we were talking as to when I did all of these things that you're talking about. They seem to be more than the number of years that I have lived. Good evening, everybody. Vice Chancellor, Professor Sibongile Mutwa, Professor Lynn Biggs, Dean of the Faculty of Law, the Judge President of the Eastern Cape Division of the High Court, and my colleague, Judge Mxenge, to the Mxenge family, Lulu, it's good to see you. Unkuli ukwan? No? Oh, and Nonkululeko then in absentia. And Buntle, I see Buntle next to you. The grandson, who I learn is one of our students at Nelson Mandela University. So we claim you today, Buntle. Deputy Vice Chancellor, Dr. Mxenge, and other DVCs that are present today. The Registrar, Mr. de Kock, Edgar. Guests from the Department of Higher Education and Training, the university management, my fellow council members. I haven't seen any today, but I'm sure they will see this sometime. I'm particularly honored to be part of this gathering tonight and to join the list of illustrious speakers who have given this lecture before in honor of the tribute and to give tribute to these two courageous civil rights icons. Mr. Griffiths Mlungisi and Mrs. Victoria Nonyamezelo Mxenge are people that we looked up to when I was doing articles in Durban. I never actually got to talk to them, but they were people that I saw all the time and heard of all the time. And before I spoke to them, I think Mr. Mxenge actually died whilst I was at university, and Mrs. Mxenge died when I was doing articles. But we were all in Durban and all in the same circles. I always feel so sad that I never got to meet them personally, and we were so much in awe of them. I wouldn't even dare to go and introduce myself to them. In an article titled, "Black Lawyers Under Apartheid, the Soul of African Lawyers," Mr. Kenneth Brown, published in the American Bar Association, together with Gestor, writes as follows about Mr. and Mrs. Mxenge. Griffiths and Victoria Mxenge, husband and wife, were among the nation's most influential lawyers in the 1970s. They represented many individuals charged with security offenses and were active in organizing their community. They were murdered nearly 5 years apart in 1981 and 1985. In 1985, former police officers, Dirk Coetzee, were found guilty of the murder of Mr. Mxenge. I have entitled this lecture, "Holding Out for the Long Arm of the Law," because of the long wait which this family and many other families in the same position have had to endure for justice to be served in relation to the death of their loved ones. But in this context, the long arm of the law refers to what we are seeing, particularly the reopening of these inquests, signifying the long reach of our laws, particularly the principles enshrined in our Constitution, the supremacy of the law and the rule of law, which we all turn to for protection and vindication when we are confronted with injustices that we cannot resolve through our own personal means. When a magistrate refused to hold a formal inquest hearing into the death of Mrs. Mxenge, he said that she was murdered by unknown persons. The Truth and Reconciliation Commission report on investigation into her death documents that A Mr. Marvin Sifako, alias Bongi Raymond Malinga, confessed to killing Mr. Mxenge. Malinga said that he had been recruited into the security branch of the South African police by a Brigadier Swanepoel, and that Brigadier Swanepoel was his handler. Dirk Coetzee, commander of C1 Flag Plus unit, brought an application for amnesty before the TRC for the death of Mr. Mxenge. Before that amnesty application could be considered, he and his unit members were charged with Mr. Mxenge's death, together with David Chikalanga and Almond Nofemela. They were convicted in 1997, but they were later granted amnesty. Other members of that unit, a certain Mr. Taylor and Van der Merwe, were acquitted by the court. An article in the edition of the 8th of March 2013 of the Time Live digital newspaper reads that Dirk Coetzee, former Flag Plus commander, is granted amnesty for murder of anti-apartheid attorney Griffiths Mxenge, Durban, 1996. That was the heading. And the article started as follows. The death of Dirk Coetzee, commander of the apartheid-era covert police unit at Flag Plus in Pretoria, has been met with venom and condolences, and the loss of hope of South Africa finding out what he knew. The National Prosecuting Authority Missing Persons Task Team said it had hoped to take Coetzee in just a few months' time to identify yet another site of a killing in Komatipoort in Mpumalanga, where the body of Sizwe Kondile was burnt in 1981. Now it's more than 4 decades after these murders of Mr. and Mrs. Mxenge that the inquests into their deaths are now being reopened. It's a milestone that brings back the hope that in the Time Live article was described as lost hope. Together with those of a number of other struggle heroes, including Chief Albert Luthuli, civic leaders Boyi Manki, and the CRADOC 4 that the VC has referred to. These are the inquests that have just been reopened. Other inquests that were reopened relate to the death of Ahmed Timol, Dr. Hussein Hafaji, and Imam Abdullah Haron. There may be many others, I'm sure, that I do not know of or that I haven't captured. These latter ones have been finalized. When announcing the reopening of the inquests into these deaths, Minister Lamula, then Minister of Justice and Correctional Services, said, "With these inquests, we open very real wounds, which are more difficult to open 30 years into our democracy. But nonetheless, the interests of justice can never be bound by the time. The truth must prevail." Regarding Mr. Mxenge, the minister said that 2 years after his death, an inquest failed to identify the perpetrators, despite clear signs of foul play, including the evidence of surveillance on Mr. Mxenge's office and the poisoning of his dogs. The minister said there is new evidence that certain critical information was not presented to the TRC, and that the initial inquest At the initial inquest, although perpetrators were clearly identified, there was information that was held back. I thought then I should take a peek at a judgment by Judge Billy Mutle, who presided over the finalized inquest of Ahmed Timol, to get a sense of what the Mxenge family and other families are in for over the next few months, or maybe years. These things take time. At paragraph 7 of the report, Justice Mutle says, "It is opposite to state upfront that this 2017 reopened inquest started off with a limp. So the Mxenge family must not be discouraged with the postponements that it has experienced. This is what is going to happen. Firstly, the inquest relates to an incident which occurred 46 years ago. That was the Timol inquest. As it turns out of about 30 members of the security branch of the South African police involved in the arrest, detentions, as well as investigations of the case concerning Timol's death, only 3 were still alive at the time that the inquest started. 2 of the 3 former police officers who testified during the hearing of oral evidence in 1972, the first inquest, were served with subpoenas to testify again in the 2017 inquest. And they were in attendance during the proceedings. So there is hope that even if not all, some of the people will be there to testify. The findings of the court in the Timol inquest range from what may seem to be mundane pronouncements, such as the correct or legitimate identification of Mr. Timol. In the 1972 cover-up inquest, as we now refer to it, Mr. Timol was identified as Ahmed Timol, an Asian male, 29 years, born in South Africa, teacher by profession. The judge in the second inquest, the 2017 inquest, found that he had not been identified as a South African in 2017, that the inquest magistrate deliberately referred to him as only an Asian man. The judge then ruled that Ahmed Timol would be referred to not as an Asian male, but as a South African. This may seem to be a small, insignificant findings, but the taking away of a person's identity was a big part of the system that apartheid was. More substantively, the cause of his death was changed in the later inquest, that is Timol, from a death by suicide, because that is what Mr. Timol was said to have died of, to death as a result of being pushed from the 10th floor of the window or being rolled from the roof. And thirdly, the overall prima facie finding was that in the later inquest found that the members of the security branch who were interrogating Mr. Timol on the day he died, through an act of commission or omission, murdered Mr. Timol through dolus eventualis. I know that term has assumed some popularity as a form of intent. The court identified 3 persons as accessories after the fact with regard to the crimes committed in respect of Mr. Timol for misleading the court, making contradictory statements while testifying under oath. So Judge Mutle highlights a few learnings from the Timol inquest, which was the first of its kind in South Africa. Of importance, he says that all branches of the state must ensure that the boundaries set by the Constitution for the respect of human rights and dignity should never be crossed. It should be the task of all branches of the state to begin to develop a culture of intolerance to any form of violation of human rights. One of the drawbacks he identifies, the judge, is the fact that the reopening of the inquest came late in the day when most members of the security branch involved with the interrogation of Mr. Timol and the investigation of his death had passed on. In addition, the court had to do with mysterious disappearance of portions of the 1972 inquest record that dealt with the evidence of the police officials, more especially a portion of the affidavit of Juan Rodriguez, which, according to the magistrate's judgment, explained how Timol fell from the 10th floor of the building. The key police witnesses who would have been called to testify again in regard to the events preceding the fall were not available. And the judge says this highlights the importance for future reopened inquests, that the state should ensure that the records of inquests are preserved. And that is something that we're not good at. On many occasions, it has been found. That the records of the inquest are preserved, considering that the Inquests Act 58 of 1959 provides for reopening of inquests without any limitation of time. The Timol inquest judgment also reveals that there are many more families who are seeking closure on the unanswered questions concerning the deaths of their relatives in detention. As his judge, that is Judge Mutle's his secretary, received numerous inquiries for assistance from families intending to facilitate reopening of their inquests of their own people. In the Timol judgment, the judge encouraged that Mr. Timol's family and their lawyers access the case documents before the inquest started. In other words, the members of the families looked themselves at all the documentation, and that was found to be a therapeutic process of actually seeing what these people said about your person and getting a first hand and touching those files, those documents that one did not have access to at the time. Also, in that inquest, the court considered the evidence drawn from the experiences of Advocate George Bizos, who had been involved in many inquiries of that nature, where he highlights the collusive role played by some in the magistracy, prosecuting authorities, and medical experts, as we know from past inquest proceedings. The much documented and publicized unprofessional conduct of doctors who testified in the inquest, in the Biko inquest, illustrates the point. I think one thing that we can be mindful of is that people will be corrupt. We find it easy to refer to past incidents of brutality of this nature, committed during the apartheid system, the apartheid times. But there will be abuse of public power during our time in administration as well. There will be use of public power entrusted to administer the country for nefarious causes. And as we become more comfortable in our democracy, the misuse of power becomes more ingrained in our societies. We as South African citizens must be vigilant in looking after the instruments and the institutions that sustain our democracy. The legal principles and the body of law that we rely on in all these processes is grounded in the Constitution. The Constitution requires that these principles be upheld by all arms of the state, by all individuals in this country. The long arm of the law is constituted by the comprehensive reach of these fundamental rights, which promote the values of our democracy and lay a basis for a just and equitable society. There are, at present, various conversations taking place about what we should do with our Constitution. There are debates about abandoning our Constitution. Debates about jettisoning or abandoning constitutions are not new and are not limited to this country. They arise mostly where, for some reason, there is a national crisis, where there are perceived failures of government, whether they are real or perceived, but where there is that impression. The advocates of abandonment of constitutions range from ordinary citizens to state presidents and other leaders of countries. It is said that Thomas Jefferson thought that every constitution should expire after a single generation. He put the lifetime of every generation at 19 years, and he advocated that after every 19 years they should have the United States of America should have a new constitution. He believed that the dead should not rule the living. The United States of America has the oldest constitution presently, meaning that nobody listened to him, important as he was. That constitution was never abandoned. But Thomas Jefferson's views illustrate the intergenerational conflicts or differences that we also experience as to how our country should be run. The debate relating to the South African Constitution is complex and multifaceted. It combines the challenges of reconciling the legacy of apartheid with aspirations of a democratic society. But by and large, the debate revolves around the value of this Constitution and how we should interpret it as judicial officers of this country. The reasons put forward for why we should abandon our constitutions are that limitations that hinder transformation and economic development are found in this constitution, that its protection of individual rights slows down efforts to address historical inequalities and to achieve socio-economic transformation. The argument is that the Constitution limits government power and its checks and balances, especially the power of the judiciary to review legislation and exercise of public power, restricts improperly or unjustifiably the power and ability of the democratically elected government to discharge its mandate. Some argue that our Constitution reflects Western liberal values and does not adequately address South Africa's unique context and historical legacy of colonialism and apartheid, that it needs to be replaced with a framework that is rooted in African values. The argument goes further that the South African Constitution has failed to deliver on the promises of social and economic justice. It has therefore failed in its core purpose, and therefore it must be abandoned or replaced. A quick overview of the process that landed us with this constitution is perhaps relevant. The brief history consists of the multi-stage negotiation process, which I know a number of people in this room were part of, starting with the multi-party negotiating process that was set up in 1993, that took place at CODESA, which was aimed at establishing a constitution. So it was always our intention from the start of a democracy, or even hopes of our democracy, to have a constitution. This process resulted in the interim constitution, which guided the process of drafting the final constitution. The Constitutional Assembly was the forum which was the newly elected parliament tasked with drafting the final constitution. And through a multimedia campaign of public participation, which was known as One Law for One Nation, aimed at educating and involving the citizens in the constitution-making process by conducting workshops, briefing, and other outreach activities. The Constitution was formed, and it was adopted by the National Assembly as the final constitution of this country and certified by the Constitutional Court in a 131-page judgment. That is how our constitution came about. It has now been in place for just under 30 years. When new constitutions are adopted, when the new constitution was adopted, we wanted a supreme law that would define the structure of powers of our government, that would define how we form our government, how it functions, the roles and responsibilities of the different branches, and how power is distributed amongst them. We wanted to ensure that our fundamental rights would be protected, our freedom of speech, religion, assembly, and the right to a fair trial. We wanted to ensure that there is a framework of governance and that the limitations of government power would be defined, and the mechanisms for us as citizens to hold our government accountable to prevent abuse and tyranny would be provided, that there would be mechanisms for challenging conduct of public bodies and private citizens, and seek redress for our grievances. And we wanted to make sure that there was rule of law. This is the role that the Constitution plays, a role that is fundamental to promotion of stability and democracy. My assessment is that South Africans are taking advantage of the rights and benefits and mechanisms that flow from the constitutional framework that we have. I do not by any means suggest that we are taking full advantage of the benefits that flow from the Constitution. We are probably nowhere near there, and we will probably never get there. But we are certainly keeping our courts used to full capacity. Trust me, I know I'm there. As for myself, I prefer retention of the Constitution. It is not a perfect document, but it is a crucial framework for our democracy, our governance, and our future. Former Chief Justice Pius Langa, in his article, Transformative Constitutionalism, refers to the epilogue to the interim constitution, which describes the Constitution as a historic bridge between the past and a deeply divided society, characterized by strife, conflict, untold suffering and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence, and development of opportunities for all South Africans, irrespective of color, race, class, belief, or sex. Constitutions are designed to endure in order to ensure political stability, but they are not immutable documents. They are not cast in stone such that they endure regardless of change in the circumstances and the values of citizens. Our Constitution provides the means for its own improvement and amendment. Section 74 of the Constitution outlines the procedure for its amendment. By a 2/3 majority in Parliament, the Constitution can be amended. It has, in fact, been amended 17 times in its 28 years of existence. This means that, on the average, every year and a half of its existence, there has been an amendment to the Constitution. Some are superficial amendments, but others are quite fundamental to the structure of our institutions. New constitutions do tend to be amended more frequently than older ones, especially in the earliest years. This is when the refinement and adjustment takes place as the political landscape evolves and the practical application reveals the strengths and weaknesses of the Constitution. Like ours, many constitutions are written and adopted within a specific historical context. Over time, people and governments develop a better understanding of the strengths and weaknesses of their constitution and how to amend them effectively. By way of comparison, the Constitution of India, which is 76 years old, it was adopted in 1950, 75 years old, has been amended 103 times, or had been amended as 103 times, as in 2023. I couldn't find a later amendment. This was to accommodate a wide range of issues, including land reforms and reservation policies, fundamental rights, and governance. The Brazilian Constitution, which is 28 years old, adopted in 1988. I don't know, my maths is not good. Adopted in, hold on to that, 1988. It has been amended 134 times. In fact, Brazil has had 7 constitutions, like wholesale constitutions, since gaining independence in 1822. Kenya has had 3 constitutions since gaining independence in December 1962. Their present constitution, I think, is a mirror image of ours. So people still see good in some things that we do and have. I do not get the impression that the majority of the people in this country are advocating for a wholesale abandonment of the Constitution. The ongoing discussions are about the refinement of the role of the Constitution and its implementation. These debates are healthy. They are a healthy part of our democracy, but we must engage in them honestly. The starting point is that we must just read the Constitution so that our conversations are authentic and our contributions are framed in informed and informative terms. My suspicion is that some of the criticism of the Constitution are not informed, or at least informative, in the way that they are presented. And I suspect that this stems from some misunderstanding or just not having actually properly read the Constitution. And I will refer to some of them and give a sort of a response, my take on what my response would be. Firstly, that the Constitution is an unjustified constraint on democratic public power. My understanding is that the checks and balances are necessary for a functioning democracy and to prevent authoritarianism. And we have seen on numerous occasions how the exercise of public power is tested and challenged in courts, and how the checks and balances work. Another criticism is that it is a Eurocentric document imposed on Africans. I have outlined the process by which the Constitution was established. I do not think it was imposed. The process, as I have outlined, involved political parties and civil society. The Constitution does reflect certain Western legal traditions, but it also expressly commands development of common law and application of indigenous law and values. The other criticism is that it hinders socio-economic transformation, especially land reform. The Constitution does contain clauses that protect property rights, but it also contains provisions for land reform and social and economic rights. Whether and how we have been diligent in implementing the relevant provisions is a different question. But the Constitution does provide a framework for addressing historical injustices. Another criticism is that it is purely a legal document and does not promote social justice. The Constitution is a social and political document. The Bill of Rights aims to create a society that is grounded in the values of human dignity, equality, and social justice. The preamble states that its purpose is to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental rights. What is the role of the three arms of government in the implementation of the Constitution? I will talk more about the judiciary and just a little bit about the executive. The challenges that we are experiencing with the implementation of the Constitution are well documented. Lack of strong political commitment hinders implementation of the Constitution. Corruption, which undermines the rule of law and diverts resources that are intended for implementation of laws and policies. Capacity constraints, these also have the same effect as corruption, except that the resources are wasted rather than being diverted to specific people. And social and economic inequality, which makes it difficult for the vast majority of all citizens to enjoy the rights guaranteed in the Constitution. Serious complaints and criticisms that have been directed at the judiciary abound, that it is susceptible to political influence, that there is judicialization of politics, that the judiciary oversteps its boundaries and encroaches on the powers of other branches of government, and that judgments lack clarity, which frustrates implementation and can cause confusion. Sentiments on the counter-majoritarian dilemma loom large. That is the question as to how a group of unelected and representative judges are empowered to overrule the will of the people expressed through their elected leaders. The judiciary has to be alive to these criticisms and confront and deal with them because indeed the system of checks and balances that is mandated between the different arms of government applies only to a very limited extent to the judiciary. And it is of utmost importance that the judiciary conducts itself with utmost credibility. As former Chief Justice Mohammed said, society is entitled to demand from judges fidelity to these qualities in the judicial temper, which legitimize the exercise of judicial power. Many and subtle are qualities which define that temper. Conspicuous amongst them are scholarship, experience, dignity, rationality, courage, forensic skills, capacity for articulation, diligence, intellectual integrity, and energy. More difficult to articulate, but arguably even more crucial to that temper is that quality called wisdom, enriched as it must be by a substantial measure of humility and by an instinctive moral ability to distinguish between right and wrong, and sometimes the more agonizing ability to weigh two rights and two wrongs against each other, which comes from consciousness of our imperfection, close quote. Public confidence in the judiciary is important because it underpins the rule of law, I think the VC said. It ensures the legitimacy of judicial decisions and fosters social cohesion. People obey our judgments because they respect the judiciary. Without public trust, the authority of the judiciary weakens and can lead to citizens resorting to self-help and undermining the legal system. But criticisms of the judiciary must be constructive in the sense that they must be specified and factual rather than generalized. Constructive criticism identifies specific errors in a judgment or point to alternative interpretations or reasonings that highlight manifestations of potential biases or impartiality. Unsubstantiated personal attacks on judges, general accusations of corruption or bias, and general condemnations of the judiciary do not add value to our democracy. Constructive criticism does and demonstrates a commitment to a strong, fair, and just legal system. It focuses on the substance of a judgment or conduct of a judicial officer and highlights areas where the judiciary can improve its efficiencies. Constructive criticism is a crucial part of a healthy democracy. It promotes accountability, transparency, and improvement, and it strengthens the integrity of judicial officers. But our legal system will still not function effectively if institutions that complement its work do not function effectively or are compromised. Even though the judiciary is independent, it relies on police investigators and prosecution to bring cases before the courts. If prosecution is paralyzed by lack of resources and lack of capacity, delays will result, and the ability of the judiciary to properly administer justice will be hampered. When there is no proper investigation of cases, the backlogs and delays will result in a slowdown of the entire criminal justice system. What members of the public experience then is lack of service delivery by the whole justice machinery. It is of no interest to them that only one facet of the chain of service is failing. The public is not interested in explanations that the judiciary does not initiate investigations. And the overall result is erosion of public trust in the judiciary and a sense of impunity on the part of offenders. The inquests to the deaths of Chief Lutuli, Mr. and Mrs. Mxenge, and many others were delayed because of a system in which there was no accountability, and that was deliberate. There was no real investigation of the real causes of death, and the original inquests did not fully investigate the circumstances in which the deaths occurred. In our cases, we have a constitutional framework, we have laws that have been enacted in line with that framework. There is no excuse for us not delivering the service that the people need. The value of reopening of these inquests will not only be enjoyed by the Luthuli and Mxenge families, or Timol, Haron, and other families. These inquests begin to record the identities of the people who were involved in atrocities against struggle activists. They reveal the systematic and blatant nature of the murders, collusion between the killers and professionals, and also collusion and lack of will, particularly with the magistrates and judges of the time, some of them, let me say, in covering up or intentionally ignoring evidence of brutality and misrepresenting circumstances surrounding the deaths, often rendering findings of accidental and suicidal causes, legitimizing the conduct of the killers. So, to the Mxenge family, as you embark on this journey of truth-seeking, we congratulate you for your tenacity. We thank you for your efforts that will add another leaf to our history, and hope that our legal system will vindicate the death of your loved ones. Thank you very much for listening to me.
Thank you, Justice Dambuza, for your enlightening lecture that resonates deeply with the values cherished by Griffiths and Victoria Mxenge. On behalf of the Mandela University, please accept this offer or this gift as our token of appreciation. I would now like to invite members of the audience to pose a few questions to Justice Dambuza. Should you have a question, please raise your hand, and Advocate Lindy Kutsia will bring the microphone to you if you are chosen. Please provide your name and your affiliation before asking your question. Oh, we have a question at the back.
My name is Opulunda Selelo. I'm a fourth year LLB student. Firstly, thank you for the lecture. I think it's imperative for us, the youth, to know of these stories and to have an idea of what is happening. There's a history that must be kept alive for so many years. The question that I'm having is, it's been 46 years. Maybe from your side and experience and all taken into account, what's the likelihood that justice will prevail? The likelihood of finding that the findings are like 100% of what has happened. I mean, yes, you did highlight that some of the police officials were there in 1976, some are still alive in there, but I'm asking this from, like, yes, we might have an inquest, but is will it breed any results? Just having it there, maybe some of the evidence is gone, missing, and people who would be able to give answers are no longer there. So at this point in time, are we really, or how likely are we to finally get to hear the 100% truth of what happened to the Mxenge family members? Ngiyabonga.
I'm not sure that I got everything that you said, but the gist of it, I suppose, is whether this whole exercise is worth the trouble. Will there be vindication of the death of the deceased people? Look, this is not, there are no guarantees. I think that's the starting point. There are no guarantees, and also, I think there's the other way of, the best way of looking at it is not from the end, but look at the process as it is. Look at what has happened in other similar processes, and success of these processes does not depend only on people going to jail. That is why I was explaining that people were given back their identity, even if posthumously they are not there. And there was accountability for those people that were there. And look, with Mr. Timol, I think he died in the early 70s. The Mxenges died in the 80s. I mean, we were there. We were already young adults. So the probabilities are that there will be many more people that are tracked down that relate to that incident. But at the end of the day, it depends on what we are looking for in a process. The families that started this process and insisted that there must be some accountability, or we want to know what really happened, know what they were looking for. And I'm sure they did consider these likelihoods that the process might not yield the ultimate vindication that they saw. So it's not a 100% all or nothing process. That's the best response I can give.
Honorable Justice, thank you for the speech. That was a great one. My name is Soletu Mkhuzu. I'm also a final year student. My question is centered around the amendments of the Constitution. How do we then deal with the dilemma of having a Constitution held as one of the best, but people are calling for amendments and doesn't truly reflect the true realities of the people? Thank you.
I'm going to answer this question by another question, because I'm going to ask you to tell me which part of which section of the Constitution are you referring to? What do you mean? Because I set out, unfortunately I forgot my little Constitution that I carry with me everywhere. It's easy to frame a question as you're doing, to say, this does not provide for me, or this does not provide for the people. But there are so many provisions in that Constitution. And it's what I think hampers the discussions that we have about the amendments in the Constitution is that we don't have specificity. If you want to say the Constitution must be amended, you must point to a particular provision in the Constitution. If you can't do that, then it means you're saying the whole Constitution must be abandoned. So your question does not enable me to respond properly. Because I don't understand what you mean if you say it doesn't reflect the will of the people. From its preamble, which I quoted, my take is that it does. All the sections in the Bill of Rights that speak to dignity of the people. And what you must understand as well is that the Constitution provides a framework. It's not the doing act. There are statutes that are enacted to take forward the framework that is built in the Constitution. You understand what I mean? The Constitution, when you look at Section 9 of the Constitution that talks about dignity, you can't say then the Constitution must implement dignity. But us, as interpreters of the laws, we will interpret them against the background that is set in those specific provisions of the Bill of Rights. You understand? Okay, no, I can't do better than that.
No, thank you, Honorable Justice. With regards to the specific section that this is for me personally that I've seen most people, even in the country, even on some political parties, is particularly with regards to closely related to the death penalty, as you have mentioned, dignity, and as well Section 10, which is the right to life, if I'm not mistaken, sorry. And I will fully agree with you, we cannot just abandon the whole Constitution. It's, in my view, that would cause chaos, but some provisions. Thank you.
Deputy Dean, Ms. Katia.
What?
We've got a hand here. No, apologies. Thank you very much, Justice. My name is Hlomela Poto. I'm an alumni of the law faculty. I want to ask a question as it relates to understanding that we are reflecting on, some of the great lawyers we've had. We go into an institution that's named after an incredible lawyer. And I asked this question on the backdrop that you spoke about the misuse of power, particularly with the current, political trajectory, which is volatile in our country. We have memorial lectures, we write books, but how do we adequately embrace the values, the principles, and become the litigators, the lawyers who stand by the Constitution? Because you find that we look at, Mxenge. I'm also, when I look at people like you, I'm like, can I get there? And so instead of just merely looking at it as a mirror, how is it seen in practice? How do we ensure when we ask and speak about the Constitution, it's not a paper, but a living document that speaks about the issues and expresses the needs, the hopes, and where we come from as a nation? Because you find that now there's a lot of backlash against the judiciary. Some people say they are now a government. Because also we will understand, and how you spoke about, there is a failure in the state or in certain arms of government. And so we also have limitations where we do not want to tap in there. But the reality is that we have a responsibility in which we also need to ensure we empower the Constitution. If you think about, as I conclude, Thuli Madonsela, before she got into office, a lot of people didn't know that there was a public protector. Her responsibility was to tap to the president and whisper to power that, Chief, I think you went the wrong way. But instead, she stands up and writes a damning report that exposes, in the form of the state capture. So she stuck to her mandate. She understood what she'd said when she took it oath of office. And she did not simply say, I idolize these people, but she ensured that the values and principles are translated in how we behave.
I don't know whether I can't remember the question now. But I think, but I understand the nub of what you're saying. And I can only answer it as shortly as this, that our duty as citizens is to hold government, all the state, arms of the state, accountable. There are methods of doing so are provided in the various legislations, but our duty is to hold them accountable, find a way of doing so. That is the best way that this constitution will work, that all of us do our part. There is a responsibility on civil society and individuals as well. So find out what your responsibility is and do it.
Joaquin van Dijk, Nelson Mandela University. Judge, thank you so much for coming and for starting the conversation on the importance of the Constitution and the need for it. But I don't want to touch on that. I'll leave that for the classroom. I'm very interested in the first part of your offering or your speech, where you mentioned the hope. I think the opening of inquest into the death of all the people you've referred to is very promising. And I was thinking about whether families of women who've been killed and there's no criminal proceedings, or members of the LGBTQI community, can they take some hope from the fact that regardless of how long something will eventually happen, should they also hope that the long arm of the law will finally, or one day, get to reach them? Are you also giving hope to them, or do you have anything to say about that? Thanks.
Thank you. I think you have extended it so appropriately, more than what came into mind. I think this is going to be an era of making the best out of the inquest system, because inquests are procedures where the cause of the death, or the person that caused the death of a deceased, is unidentified or unidentifiable. They provide, because it's an inquisitorial process. It's not like court where, it's adversarial and there's a lot of that tension and cross-examination and all of that. So whether it's the death, any death, let me say, whether it's from the deceased or the victim is a member of the LGBTIQ community, or a person killed by a motor vehicle, hit and run, any death where the cause or the perpetrator is not identified. Thanks.
Thank you, Chief Justice.
Did you say
Acting
Chief Justice?
Maybe that is yet to come, Justice Dambuza. Greetings to you, to the JP, and also the Mxenge family. My name is Makaya, graduate from Walter Sisulu University, admitted attorney of the High Court of South Africa, and also conveyancer. Apologies if this question will take you back a bit, but it is more in line with the issue or the points or statements we made about the Constitution. And my question is, what is the judiciary has in place to ensure that the people that it appoints to the judiciary are credible? As you said, that the judiciary is there to actually safeguard, defend, or protect the Constitution. So my question is are there any measures that the judiciary has to make sure that it remains independent, as we have rise in terms of corruption and political influence into the justice system? Thank you, Chief Justice. Justice Dambuza.
Yes, there is a complaints system. First of all, the appointment of judges is an open system. The people that sit in the Judicial Services Commission that appoints judges are drawn from all sectors of the state. There's parliamentarians, there's people from the judiciary, there's from the practitioners and everybody. So that is the way in which people enter the judiciary. And those interviews are transparent. We see them all the time on TV. Maintaining credibility. Any person who has a grievance against a judge is entitled to approach the committee of the Judicial Services Commission, which is called the Judicial Conduct Committee. You go to the Office of the Chief Justice, there's somebody there that helps you lay your complaint, and that is the system of accountability. There is the Judicial Code of Conduct, which you can measure the particular conduct that you are aggrieved against. Judicial Code of Conduct, what's the other one? But there are those instruments that are provided, I think, under the Judicial Services Act to facilitate those processes.
Thank you, Judge Dambuza, and thank you for your insightful lecture this afternoon. My name is Linton Armse. I'm attached to the Refugee Rights Center at Nelson Mandela University. Among several things that you said resonated with me, but I want to highlight one specific aspect. When you referred to the judge in the Ahmed Timol inquest, and you said that the judge remarked that we should develop an intolerance for the violation of human rights. I want to let that sink in. An intolerance for the violation of human rights. That resonated with me quite particularly. What do we find now? Violation of human rights, and a specific example now would be violation of the human rights of foreign nationals in South Africa. We have recently seen that they were even prevented medical care at public hospitals. And the authorities who were supposed to act were silent. They looked the other way. My question is, which sector of society's human rights will be violated tomorrow, and we look the other way? I want to link that with the Griffiths family, Mxenge family, sorry, Victoria and Griffiths. The authorities also look the other way. Their deaths were not properly investigated. The magistrates didn't do what they were supposed to do. There was no intolerance for the violation of human rights. That happened then, but it's happening now again. Are we not learning from history? Shouldn't that be a red flag for all of us? And you have said also, all of us, correctly so, must hold government and authorities accountable. Just your views on that, please.
Is there a question there? I agree with you entirely.
Thank you, everyone. That is the end of the Q&A session. I now kindly request Dr. Muki Moeng, the Deputy Vice-Chancellor, Learning and Teaching, to do the vote of thanks.
Honored guest speaker, Acting Justice of the Constitutional Court and Nelson Mandela University Chairperson of Council. Thank you. Justice Nambitha Dambuza, Chief Justice. Our Vice Chancellor, Professor Sibongile Mutwa, the members of the Mxenge family, Bundle, our student. We are proud. Judge President of the Eastern Cape, representatives of different law societies, the bar. I also had a question about the sidebar, and the Department of Justice and Constitutional Development, and the Department of Higher Education and Training, members of the university management that are here, the Deputy Vice Chancellors, the Registrar, lecturers, academics, administrators, the Executive Deans, in particular, the Executive Dean of the Faculty of Law, Dr. Lynn Biggs, Deputy Deans and Senior Directors. Honored guests, family and friends, Molweni, good evening, goeienaand. Mine is to do the vote of thanks. I would like to thank everyone here in person and those who joined us virtually for joining us for this public lecture this evening. Nelson Mandela University is truly grateful for your presence and the energy that you brought through your participation and engagement. Your insightful questions made this event incredibly valuable. It is such a pleasure to see everyone here, in particular, the law students who asked these very important questions. I'm proud of you. The Mandela University community and our wider community. Thank you to the program director for ably directing the program. I would like to thank our honored guest speaker, Acting Justice of the Constitutional Court and Nelson Mandela University Chairperson of Council, Justice Nambitha Dambuza, for her outstanding, insightful, stimulating, and inspiring address. For me, this was a masterclass. It was. It was a pleasure having you and listening to you, Judge. Your expertise and insights on the holding out of the long arm of the law captivated our audience and certainly left a lasting impression on us. The engagement this evening is testament to your meaningful contribution to the legal discourse and the demystification of law to our publics. Issues on identity, the Constitution as a framework of democracy, our values, and basis of power. So thank you so much for that. So once again, thank you for being an integral part of our university. I'd like to thank our Vice Chancellor, Professor Sibongile Mutwa, for warmly welcoming us this evening. Your welcome address set the tone for this evening and made us feel at home. Thank you to the University Choir for their beautiful rendition earlier on. I would also like to thank the family for having given us the honor to name this public lecture after these special human beings and legal giants. I would also like to thank them for honoring our invitation and attending today. We are truly honored as Nelson Mandela University. I'd like to thank the Faculty of Law for their impressive organization and making this public lecture a constant occurrence on our university calendar. Thank you to our colleagues in communication and marketing for giving this event exposure and the running around behind the scenes. Thank you to the students, administrators, and everyone who has made this event a success. Thank you once more for your time and support. Please travel safely and enjoy your evening further, but also join us in the foyer for some refreshments. Thank you very much, Nkosi kakhulu, bayadanki.